The
Institute for Justice.
The National Law Firm for Liberty.
Hello, and welcome to Short Circuit, your podcast on the Federal Courts of Appeals. I'm your host, Anthony Sanders, Director of the Center for Judicial Engagement at the Institute for Justice. We're recording this on Thursday, November 18th, 2021. Please check out our newsletter by the same name and our much better podcast, Bound by Oath. A legal rule forbids you to take a vehicle into the public park. Plainly, this forbids an automobile. But what about bicycles, roller skates, toy automobiles? What about airplanes? Are these, as we say, to be called vehicles for the purpose of the rule or not? That is my best impersonation of the English legal philosopher HLA Hart, and I apologize for that. It's a couple lines from his 1958 article, The Separation of Law and Morals, where he uses the example of the rule, no vehicles in the park, to argue that although the penumbras of legal rules are often indeterminate, such as a toy car or an aeroplane, their core generally have a settled meaning. It's like an automobile. It's an example that listeners who went to law school probably remember, and most who didn't have likely been spared worrying about. But last week, the D.C. Circuit had to worry about it because a case before the court concerned the meaning of that exact word, vehicles, and whether its use in a statute covered semi-truck trailers. Now, both HLA Hart and his sparring partner on that issue, Fuller, are no longer with us. But one legal philosopher who is IJ's Jeff Redfern. Jeff, a former clerk of the D.C. Circuit, is going to let us into their vehicular thinking. Also with us is IJ's Paul Sherman. He's got an election law case from the Ninth Circuit and is going to give us some graphological facts about an issue he's discussed on Short Circuit before, soliciting signatures to try to get on the ballot. Apparently, that's a hard thing to do under the big sky of Montana. But first, before we turn to Jeff's case, I want to throw it open to the panel. Did either of you, Jeff or Paul, read about no vehicles in the park in law school, or was just something weird about my legislation class?
No, I read about it. I remember it from 1L. And it's the classic example. And we were asked, is a wheelchair a vehicle? What about a motorized wheelchair? And I think most of us were missing the point of the exercise at the time. But it did inspire some lively debate.
And Jeff, you too? The halls of Harvard, you talked about no vehicles?
We did, but I almost missed it. It wasn't anything we touched on in 1L. It was a 3L jurisprudence class where we read HLA Hart, and then no vehicles in the park became a recurring example as we were reading Dworkin and other legal philosophers, regardless of whether they had written about it specifically.
Well, I'm glad you got to revisit those glory days then with this emissions standards case. So you can tell us some more about no vehicles in the park, and then also what the U.S. government's trying to do with the apparently the tailpipes of these trailers, which of course aren't vehicles, so they don't have tailpipes.
That's right. So this is a case called Truck Trailer Manufacturers Association v. EPA. It's out of the the D.C. Circuit. And it's about new rules that were promulgated jointly by both the EPA and the National Highway Transportation Safety Administration, or NHTSA. These rules require 18-wheel trailers to have certain features to make them more aerodynamic, like tire pressure monitoring and aerodynamic skirts, things that will improve the fuel economy of the vehicles that are pulling them. Now, although these are joint rules, the agencies invoked different statutory authority. I guess there are two ideas here. One is that if you have two different agencies regulating about the same subject matter, you're going to hope that they're talking to each other and not regulating in an inconsistent way. The other idea, I guess, is that if one of these rules gets struck down, you have another shot at keeping it in place because they're invoking different statutory authority. So, unsurprisingly, the Truck Trailers Manufacturers Association, not a trade association I was familiar with before this litigation, sued. And it argued that the agencies didn't have the power to impose these rules. So starting with the EPA, the court agreed, all three members, and they said that the EPA was invoking the Clean Air Act, which allows the agency to regulate the emissions of motor vehicles. And the statute has a definition of the term motor vehicles. It says it's something that's self-propelled. So the court said, this is pretty easy. Obviously, the entire point of a trailer is that it is not self-propelled. It has to be propelled by something else. Now, the EPA argued that it was just regulating a vehicle component, that a trailer is a component of a semi-truck. But the court said, if that's true, then the EPA could regulate bicycle racks, because if you put a bicycle rack on top of your car, that's going to impact your car's fuel economy. But nobody would say that that's a part of your car. The car works just fine without it. Now, the EPA offered a limiting construction. It said that it can only regulate significant components. The court says, well, there's nothing in the statute about significant components. That's just a limitation that you made up. Now, this is a classic mistake that I see government lawyers make. Maybe it's not fair to call it a mistake. It happens even at the Supreme Court level, where they know that they have an argument that's really broad, so they come up with a limiting principle, and it's not something that's really based in the statute. They just kind of came up with it. And maybe that's the best way to go sometimes, because if you're stuck, defending a rule that somebody else wrote, an atextual limiting principle might be better than none. On the other hand, sometimes maybe it's better to just embrace the implications of your argument and say, yeah, we could regulate, bike racks, and we just don't. That's a tactical call that they had to make here. So much for EPA's rule. I think that was a pretty straightforward case because of that explicit statutory definition of motor vehicles. Now, NHTSA's rule is a bit trickier, though. The statute that NHTSA was invoking allows it to issue rules to improve the fuel economy of commercial heavy-duty vehicles, which include semi-trucks. Now, the D.C. Circuit majority said that this doesn't allow for the regulation of trailers either, because a trailer itself doesn't have fuel economy or use fuel. And the cab portion of a truck is already a vehicle before any trailer is attached to it. Now, this is where the majority brings in the famous no vehicles in the park hypothetical. It says, if you have this rule, it could be difficult to determine what counts, but you can usually figure out from context what's intended. And they say, look, if we read this, everything is about, it's about fuel economy. It's about vehicles that are consuming fuel. We can figure out from context that this is a statute that is about things like, the semi-cab that does the pulling, not about the various things it might or might not pull at various times. Now, this is where Judge Millett in dissent parts ways with the majority. She agreed on the EPA's rule being unlawful, but she says that vehicle is not defined in NHTSA statute. So under Chevron deference, it's perfectly reasonable to interpret vehicle as including the trailer. In common usage, if you're driving down the highway and you see a semi-truck with a trailer attached, you don't normally say there's a semi-truck and a trailer. You call the whole thing a truck. And I think...
Hey, Jeff?
Yeah.
Could you explain what Chevron deference is? Because it's very common in our work, but I think many of our listeners might not know what it is.
Sure. Apologies for jumping the gun on that. So Chevron deference is the principle that an agency that has been delegated the authority to implement a statute is entitled to interpret ambiguity in that statute in an authoritative way. So essentially, if the statute doesn't explicitly say that a term has to be read a particular way, courts will defer to the agency's reasonable interpretations of that term, which is different from what happens if we have a statute that is not entrusted to an agency. Then the court is going to figure out what it means, even if it's a really tough case. In a Chevron case, they'll say, you know what, if it's not totally clear, the agency gets to decide what the law means.
Yeah, and I think one thing that might be interesting to our readers is Chevron deference has been around for a long, long time, but more recently it has come under attack, particularly from more conservative jurists, and textualists, because they have started to see it as a usurpation of their power to interpret statutes. It's being improperly given to the agency. So that's just something for listeners to have in the background of their mind as they're trying to understand the differences between the majority and the dissent here.
That's exactly right. And I think what's interesting about these dueling opinions here is even though the majority here is not challenging whether Chevron deference applies, in fact, he can't really. It's for the Supreme Court to overrule that. You see how more conservative jurists apply Chevron deference. So traditionally, they say there are two steps to Chevron. At step one, you ask if the statute is clear, and you apply all the tools of statutory construction. And at step two, if it's not clear, you ask if the agency's interpretation is reasonable. And typically, the more conservative jurists will push a lot harder on step one. They're far less likely to say, well, this statute is unclear, so the agency gets to do it. They'll say, we're going to keep taking the tools out of our toolbox. We're going to look at the context. We're going to bring out all the dictionaries. And they're far less likely to say that this is an unclear statute, that the agency gets to decide what it means. On the other hand, although Judge Millett found this an ambiguous statute, it's interesting to see how she really used a lot of the same tools. She cites, multiple dictionaries. She's using these Latin tools of construction, such as nocitar sosis, where you look at a list of terms and say that if one of these is unclear, then you should read it to be similar to the other terms in a list. And I think it really illustrates something that Justice Kagan said at her confirmation hearing famously a number of years ago now. She said, we're all textualists now. Whether you're a quote unquote liberal or conservative jurist, basically most judges on the federal bench agree that the words of statutes matter, and they're paying much closer attention to the words of statutes than they did in decades past.
And it seems like the difference between them here is one uses those tools before applying Chevron and just doesn't because it's unambiguous, and one does it after applying Chevron. Big difference.
That's right. And I think that it illustrates, I think it's a difficult question. Assume if you have to apply Chevron and, as lower court judges, you have to treat that as correct. It's not your prerogative to overrule it. It's hard to say, how do you draw the line? When is something clear enough? Because in every other context, when a judge confronts a statute, they have to come up with an answer, and they apply these tools until they come up with an answer. So there aren't really clear lines about when something's clear enough that you've passed that step one hurdle, which is, I think, one of the problems with Chevron deference. It's very much in the eye of the beholder when something is clear enough. Whereas if you say, look, you just have to come to the best answer, then at least the judges agree about what they're supposed to be doing.
Going back to that, this is I guess a small point, but related point on how things have become more textualist. Is you said that the lawyer and the government lawyer in this case, they had a limiting principle, but it was kind of just made up. It wasn't based on the text in that one argument. I wonder if 40 years ago, when textualism wasn't really a big thing and people looked at legislative history and all kinds of, or judges did, and all kinds of other sources in trying to discern a statute, that was just a common tactic. And so maybe this lawyer used it because there just wasn't anything else, but maybe it's kind of a remnant of that type of agency lawyering, is that you come up with limiting principles that just make sense almost in a kind of a common law process, but you have this more positivist, textualist judge standing in front of you that's not interested in hearing that.
That makes sense to me. I mean, I have no idea, who these specific lawyers litigating this case were, but I certainly think this is the kind of argument that would not have gotten the back of the hand in the middle of the 20th century.
Yeah, I've been burned by something like this in one of my cases, and I don't want to get too specific because the judge is still on the bench. We were challenging a licensing scheme. The wording of the scheme was I think unambiguous and extremely broad, and that's how we briefed it. And then when we got into argument, basically on the day of argument, the government came in and was like, "Oh no, this is limited in the following ways," that really had no basis in the statute. And the judge was like, "Okay, well, I've heard enough." And we ended up losing the case on those grounds. Although the flip side of that was that they did bind themselves to this narrower interpretation, which actually did open up the occupation in some ways, even though we didn't kill the entire scheme.
Well, someone whose scheme was killed, it seems, was the Green Party in Montana a couple election cycles ago when they tried to get a primary and were not able to because of some signature requirements. Paul, tell us what was going on in Montana with this case, Montana Green Party versus Jacobson. I have some questions about exactly how their signature drive worked, it sounds pretty bizarre from the facts. But give us some of the background here and why they were somewhat successful and somewhat unsuccessful.
Yeah, so this is a really interesting case. And, my background initially was in campaign finance law. And so I'm very familiar with that branch of election law. But that's not the only branch of election law. And a significant branch is ballot access law. For those who are interested in ballot access law, I just want to put in a plug at the beginning here for a website called Ballot Access News. It's been online for years and years. It's kind of a one-man operation, but it does an absolutely excellent job of tracking all the litigation in this area. So if it's an issue you're interested in, definitely check out Ballot Access.
We'll put a
News.
link up to it in the show notes too for those who are interested.
Yeah. So Anthony, as you mentioned, the Green Party of Montana wanted to get on the ballot for primary elections. And so there were two ways for them to qualify for this. The first was if within the last two elections, any statewide candidate from that party had gotten 5% of the votes of the last successful gubernatorial candidate. That is extremely difficult to do. And in fact, the only time a minor party has ever done that in Montana was in 2004 when the Green Party was able to have a primary because of Ralph Nader's very good showing in the 2000 election. But that's basically foreclosed. It's essentially impossible. The other way is to gather signatures, and it's a convoluted scheme that they have that I will try my best to explain.
Unfortunately, we don't have charts for our listeners, but maybe you can describe them, Paul.
I know, yeah. So it's, you would think a signature requirement like, just get a certain number of signatures from registered voters, and then you can be on the ballot. But Montana decided that was too easy. So what they did is they adopted this scheme where you have to get the same 5% of the same number of signatures as you would have to have had votes in the previous election, or 5,000 signatures, whichever is less. But they have to come from at least one third of the state legislative districts, and amount to either 5% of the votes received by the last successful gubernatorial candidate in that district, or 150 signatures, whichever is less. So as a result, the number of signatures you have to get in each district varies depending on the political distribution in that district. If you've got a Democratic incumbent governor and you're in a very heavily Democratic district, you're going to have to get more signatures than if you're trying to get them from a very conservative district.
And that's because the Democrat won the last election.
Yeah.
Right.
Yeah.
And also and you said this, but just to hit it home for our listeners, it's not the total number of votes for governor. It's the total number of votes for the winning gubernatorial candidate, but it's the same candidate in every district, whether he did really well in that district or terrible.
Correct. And so as a result, the required number of signatures can vary by quite a bit. So in this case, for example, Steve Bullock was the incumbent governor, and what that meant for the Green Party is that in some districts they would have to get as little as 55 signatures, and in others they would have to get up to the ceiling of 150 signatures. Now, this is the part that is actually kind of funny because there's a little bit of intrigue that happened in this case. So the Green Party went out trying to collect signatures, and they did their level best, and they came back with 699 signatures. But somebody, and we don't know who, paid a private company to go out and collect signatures. And they got 9,461 signatures. So, like many times more than what the party itself was able to gather. And the Green Party actually was not happy about this because they were, what seems to have been happening was that probably someone who was supporting whoever was going to be the more conservative Democratic candidate in the primary paid money to try to get the Green Party on the ballot so that it would maybe draw votes away from whoever the more liberal Democratic candidate would be.
So here's what I don't get about that. The Green Party's 600-something signatures, that's just astronomically too low, right?
Yes.
I mean, they had no hope. So they just go out, do a college try, get a few signatures, put it in there. No, it's not even close to enough. And this outside force gets like 9 times that amount. Over 10 times that amount. And the Green Party is mad that they also got those signatures. It's someone isn't telling the truth.
Yeah, what the Green Party says is they felt like they were sort of being used as pawns in somebody else's political game. But you're right, like there never would have been really this lawsuit if someone had not gone out and done this.
I don't even get why they're suing. They didn't even want 90% of their signatures, and then they sue they didn't get on the ballot, but they only got 600. Anyway, I am a little skeptical of that claim.
Yeah. So this actually touches on another important issue of ballot access, which is using paid signature gatherers. And there are many states that have. So if you want to get like a ballot issue on the ballot in California, that is a huge undertaking. You have to gather a tremendous number of signatures. And most people who try to do that use paid signature gatherers. And many of those signature gatherers come from out of state. And some states have tried to limit this, generally unsuccessfully because courts have struck them down, by saying that you can't have paid signature gatherers or you can't have signature gatherers from out of state, all of which impinge on the First Amendment rights of groups that are trying to raise these signatures. But anyway, that aside, they get all these signatures, they submit them, and at first they are told that they qualify for the ballot. So, hooray for the Green Party. But then, as inevitably happens in one of these situations, a major party sued. So the Democratic Party sued and managed to get 85 of the signatures invalidated. As a result, Green Party was 13 signatures short. They only qualified in 30 districts instead of the 38 districts that they needed to qualify for, and so they were off the ballot. So the Green Party sues, and it brings 2 claims. The first is a right of association claim, which is also kind of like the right to cast an effective ballot. And the second is an equal protection claim. The first one, the right of association claim, is unsuccessful before the Ninth Circuit. And this is a case that's really about the standard of review. What the Supreme Court has said is states have to have some ability to control who gets on the ballot, because otherwise it would just be, anarchy. And as much fun as that sounds to people like us, it would not be fun and certainly is not palatable to the major parties. So states have a certain amount of leeway to regulate in this area. And the first question that courts ask is, have you imposed a serious burden on association or a more minor burden on association? And if it's a serious burden, they review the law with strict scrutiny and it's likely to be struck down. If it's a less serious burden, they review it with a lower form of scrutiny and it's very likely to be upheld. And that's what happened here. They decided that these particular burdens were not super serious, and so they upheld them on this claim. But they struck them down on the equal protection claim, and this is an application of the one person, one vote principle. So under the idea of one person, one vote, a vote in one legislative district or one voting district should count the same amount as a vote in another district. And here, because of this weird geographic distribution that they had and kind of the political balance of it, as I said, you've got districts where you only need to get 55 signatures and districts where you need to get 150 signatures. And what that means is that in the 55 signature district, each of those votes counts about 3 times more than a vote in the other districts. So this is, I think, an interesting case. It doesn't break a lot of new doctrinal ground or anything like that, but it does show how these principles apply. And I think it also shows how the major parties, how hard the major parties work to try to keep minor parties off the ballot.
The thing that struck me about this is that the way the law functions in practice, requiring such varying levels of support depending on who is the governor, it just can't have been intentional. It's so bizarre that it has to have been something accidental based on the way they reformed this from the prior system, and yet here they are defending something that's absurd on its face. Like, you can't even come up with a nefarious story for why somebody would do this to advantage themselves, because in Montana the governor's mansion goes back and forth every couple of years. It's pretty evenly divided, so it's totally random who's going to be hurt or helped by this. I can't understand why they adopted this system, I mean, although it does kind of hand the burden back and forth, maybe that's something that they considered, given the fact that, they're a politically kind of evenly divided state.
Well, this is just speculation, but after all, this is a podcast. So they probably did just come up with some system because the folks writing the laws, which are all members of the two parties, I think occasionally maybe there's an independent legislator in Montana, but not really, didn't think too much about this. But I would say, I think in a sense, this rule would advantage someone who is going to draw more on rural counties than urban counties. And so it may be, if you just think of someone who's going to be more of a close competitor to Republicans than someone who's a close competitor to the Democrats. And of course, here the Green Party drawing more from people who normally are more Democratic voting. You need a higher percentage in a more Democrat district, because more people voted for the Democrat in the last gubernatorial election, and they're more likely to be in urban districts because, like the rest of the country, Montana, where I lived for a time over a decade ago, is just as you'd expect. There's a few kind of college-y towns where there's some liberal folks, and then there's very conservative rural districts. And so if you're in the more liberal districts are more compact. It's easier to go door to door and find people. You could go to a fair and, maybe fill out all you need. But the number's a lot higher there because it was a Democrat who won last time. Whereas if you go to a rural county, the number's a lot lower, but it's harder to get to people in the first place. Whereas if a Republican had won the last time, it would be a lot easier, right? And so I don't think there's anything. I think that kind of goes to your point, Jeff, that like it just flips and flops, and so that it doesn't seem like there's anything nefarious. But it does mean if you're the Green Party, you wish the Republican won last time because it would be a heck of a lot easier for you.
Yeah. And and I should be clear in discussing what the Ninth Circuit invalidated. They did not invalidate the requirement that you get signatures from 1/3 of the legislative districts. They only invalidated this 5% requirement. So, but yeah, I think you're right.
So that's still there.
Yeah. So if you've got lots of kind of compact liberal voting districts and many more sort of diffuse, low populated Republican voting districts, I think that's probably going to favor Republicans in trying to meet that 1/3 requirement, even if they have more trouble meeting the 5% requirement.
Right. Or competitors to the Republicans, you might say, so whether it's a Libertarian Party or whoever. Of course, libertarians are all over the map, as we at IJ well know. Well, thank you both for that electoral analysis and the analysis of no vehicles on the highway of a certain kind, you might say. I encourage all of you to go out and read some HLA Hart after listening to this. I hope we've inspired you for that. And then also, of course, the rebuttal by Lon Fuller, who talked about having a vehicle placed on a pedestal as a war memorial and whether that would satisfy the no vehicles at the park rule. We'll save that to a later podcast. But for now, I hope that all of you have a happy Thanksgiving where you will all get engaged.